Hello, class, and welcome back to our discussion of product liability. And we've talked a bit about the definition of product liability being the type of liability that attaches to a maker, seller, or lessor of defective goods which cause physical harm or property damage to a consumer, user, or bystander. And then we talked about the intentional tort of fraud and the distinction between that and negligence, and how negligence theory, as we learned it in our introductory discussion of torts, still applies. But we have some additional rules that we need to be aware of, some additional concepts that we need to be aware of. And so the world of product liability has evolved greatly over the 20th century, in part because of the emergence of mass production, which we are also comfortable with in the current age, that we don't think twice about it. But the very fact that, for example, we can even anticipate the mass production of thousands and thousands of masks or ventilators in our current kind of national medical crisis is a product of the fact that we can mass produce things now that we couldn't even create before, but certainly things that we created had to be created much more by hand. And so manufacturing really changed in the 20th century, certainly beginning in the mid to late 19th century, right? And during this period, and so we've got this chart here, it's meant to illustrate our next case, which is McPherson, all right? And you see Mr. McPherson sort of here on the ground. I did my best attempt at an illustration of Mr. McPherson and his circumstance. He's injured. He's been injured by his Buick automobile, right? There is a broken wheel, if you can see my, again, representation there of his 1916 Buick. It is a broken wheel, and the broken wheel caused him to be basically injured, right? He bought the automobile from the car dealer. I've named it Sam's Car Lot here. But Sam's Car Lot is not a party to this action. In fact, I don't even know if the name of this car dealer was Sam's Car Lot, right? It's irrelevant because he wants to sue the money. He wants to sue the Buick Manufacturing Company. And to further, add to this mix, a point that comes more relevant later after we discuss the holding of this case, is there is an additional party who actually manufactured the faulty, defective product. There's a wheel company that makes wheels. They sell them to Buick. Buick then incorporates the wheel into its cars, its manufactured cars. It then has a transaction with Sam's Car Lot, right? And then Sam's Car Lot had a transaction with Mr. McPherson that resulted in him driving the Buick that basically had this malfunction with the broken spoke, right? And that caused him injury, right? One thing that stood in front of Mr. McPherson and recovery was the relationship that he had with Buick Motor Company, as in none, right? Or rather, no privity. Privity is the relationship between two parties to a contract, right? So, for example, between Sam's Car Lot and Mr. McPherson, there's privity, right? But there is no privity between Mr. McPherson and Buick Motor Company. The privity is between Sam's Car Lot and Buick Motor Company, right? And in addition, the wheel maker is the actual maker of the wheel. Neither Sam's Car Lot nor Mr. McPherson have privity with the wheel maker. Only Buick has privity with that party, right? So you can see just from the illustration here that the party who's actually responsible for making the defective product is not, it's not recoverable under traditional notions of privity, because this is a matter that would have been initially, the initial hump would have been establishing a contract. Privity was the relationship between two parties to a transaction or to a contract. Privity made sense to a certain extent in a horse and buggy world if the wheel spoke caused Mr. McPherson's accident was made by his blacksmith, right? Then the party who is responsible is the party who should have taken care, and their failure to do so resulted in Mr. McPherson's accident. But in an age of mass production, this direct requirement of privity may not be sufficient to make sure that the law does what it's supposed to do. In Mr. McPherson's case, he wants to sue Buick Motor Company. His theory is that the defect, if it had been inspected, would have been easily determined. And the failure to do so was a breach of duty. And accordingly, the breach of duty resulted in him driving a defective car, and that basically ended with him being injured, right? So the holding of the case is interesting. And I've oversimplified it here, right? Number one, down with privity for things of danger. I'm being more sort of granular. I want to make sure I'm also abstracting this, right? Because I want to make sure that I'm specific. This is a 1916 case. It does not do away with privity entirely, right? But if a thing is a thing of danger, as we'll see, right, and a reasonable inspection would reveal that fact, right, then anything of danger must be carefully made, right? And the duty extends to everyone who might be impacted, all right? And so I'm going to go into a little bit of the language of the case to kind of get a sense of kind of maybe sets the stage for when we come back and we talk about, after we talk about strict liability, we have to talk about what is a defective product, right? And that is important because that is part of the proof both for negligence and for strict liability. So here they say, Justice Benjamin Cardozo stated, and this is for the New York New York Court of Appeals. If the nature of a thing is such that it is reasonably certain to place life and limb in peril when negligently made, it is then a thing of danger. If to the element of danger there is added knowledge that the thing will be used by persons other than the purchaser and used without new tests, then irrespective of contract, the manufacturer of this thing of danger is under a duty to make it carefully. And they go on to continue, beyond all question, the nature of an automobile gives warning of probable danger if its construction is defective. This automobile was designed to go 50 miles an hour. Unless its wheels were sound and strong, injury was almost certain. Although Buick itself had not manufactured the wheel, the court held that Buick had a duty to inspect the wheel, and that Buick was responsible for the finished product. Therefore, Buick was liable to McPherson for the injuries he sustained when he was thrown from the car. And so this was a landmark decision, kind of pushing privity aside, even to the extent of saying that it's specific about a thing of danger, it being a thing of danger. And this sort of begins to pick up over the course of the 20th century. By the mid-1960s, it's sort of in full swing. And after that period of the 1960s, it was generally the rule that products are, if they cause injury to any end user or bystander, and as a result of the defendant's negligence, then that completes the product liability negligence tort. So this was a significant step in creating the modern legal environment, particularly for product liability. It greatly impacts business. Technological developments have necessitated changes in the law because we mass produce so many things, right? And you don't have a blacksmith looking over each and every wheel, right? Then we have to extend both the people who are responsible, because it's not that, as we'll find, right, that the wheel company is not responsible. It's that Buick also failed to exercise care. So theoretically, they could both be responsible. Interestingly, under a strict liability theory. So here, under a negligence theory, it's clear that this case suggests that both Buick Motor Company and the wheel manufacturer, by inference, would have been negligent, right? Interestingly, under strict liability theory, both the wheel manufacturer, Buick Motor Company, and the seller, the hypothetical Sam's car lot, could also be liable. It's absolute liability. It doesn't require fault or any type of lack of care or scienter as far as intent. All right. We'll get to that shortly. In the meantime, please answer the prompt below. Thank you very much. Take care.